When saying yes to a search warrant means no. Exceeding the scope of a search warrant and compelled compliance with a request to search a locked safe. Hey, this is Alex Zouzas, author of the book Courtroom Confidential, and I'm keeping your brain on law. Today I'm going to discuss how searching a locked safe, even when the police have a search warrant and the owner of the safe agrees to open it, can be illegal. If you like the video, hit that like button and subscribe to my channel. There's two aspects to this subject. The search exceeds the scope of the search warrant, and the client's consent to open the safe is compelled. Just a reminder, I'm not giving legal advice. I'm simply analyzing a situation which can occur and discussing how I dealt with it in the past. So let's talk about the facts. As a result of an investigation into child exploitation not involving the defendant, whom I'm going to refer to as E, a warrant was issued to search a house E neither owned nor lived at. The subject of the application of the warrant was items regarding the exploitation of children, and the affidavit listed, and the warrant for that matter, listed a slew of computer hardware and software, such as CPUs, disks, hard drives, modems, application software installation and operation media, passwords, access codes, as well as any evidence concerning the exploitation of children. Regarding who could be searched, the warrant limited the search to persons located on the premises reasonably believed to be connected with the illegal activity. The only person mentioned in the application and affidavit for the warrant who was reasonably believed to be connected with that illegal activity was a guy named Hector. E was never mentioned as a suspect in the application, and there was no mention in the application of drugs or drug activity. You'll see how that's relevant. During the search of the home, the police found two safes, one large, one small. They tried, but they couldn't open the small safe. An occupant of the home told the cops that the safe wasn't his, he didn't know who the safe belonged to or what was in it, and he certainly didn't have the code to open it. Then E showed up. When asked, he told the police that the safe was his. The police also asked him if he knew the code, and if so, they told him to open it. When E said he knew the code, the police, of course, told him to open the safe. E opened the safe, and when he did, the police physically pulled him away from it and searched inside of it. Inside, they found cash, a box of plastic sandwich baggies, a digital scale, and a closed, opaque baby formula can. The police opened the can and found cocaine. I argued, among other things, that because the search of E's safe exceeded the scope of the warrant and E's consent was compelled, E's admission that the safe was his, as well as everything the cops found in the safe, especially the cocaine, should be suppressed. Now let's talk about the law. Just a reminder, you can find any of the information I relied on in drafting the motion to suppress, in that case, online. Let's begin with the general principles applicable to all search warrants. The Fourth Amendment provides that no warrants shall issue but upon probable cause. Probable cause exists when there's a fair probability that contraband or evidence of a crime will be found in a particular place. It's Illinois versus Gates. I just want to tell you now, I'm not going to give the citations to these cases. I'm just going to give you the style of the case. If any of you want the citations, just post that in the comments. I'll be happy to then post the citations to these cases. The judge issuing a search warrant then has to make a practical, common sense decision whether, given all the circumstances, there's a fair probability that what's sought is going to be found in a particular place. That's Gates. Mere speculation that some evidence of criminal activity might be found if a broad enough search is permitted is insufficient to support the issuance of a warrant. Now let's talk about the particularity requirement. The focus of this part of the video is on the rule that search warrants have to be so particular that police officers executing the warrant have little discretion as to where and what they can search, and as will be shown later in the video, whom they can search. If the scope of the search exceeds that permitted by the terms of a validly issued warrant, the subsequent seizure is unconstitutional. For example, in Polikoff v. State, a decision from Florida's 5th District Court of Appeal, the defendant moved to suppress evidence seized pursuant to a search warrant, partly on the grounds that the warrant failed to describe the items to be seized with the required particularity. The appellate court agreed, holding that the search warrant, which authorized the search for documents recording the extension of credit to the defendant, didn't meet the requirements of Article 1, Section 12 of the Florida Constitution. This case was about charging usurious interest. The court noted that documents constituting evidence of interest charged on two loans should have been so particularly and specifically described so that the police would readily recognize any document showing the defendant charged usurious interest. The court noted that nothing should have been left to the discretion of the officers executing the warrant. A search warrant has to be sufficiently specific to allow any item found and examined by an officer executing it to be readily recognizable as being or not being an item described in the warrant. Warrants attempting to authorize a search for and seizure of a class or a group of objects, such as just documents, are too general and don't describe the thing or things to be seized with the particularity that the Constitution requires. If the original source of the information upon which the search warrant relies can't describe existing objects or things other than in terms of generic references such as, again, papers and documents, the information is too vague and indefinite. Consequently, the use of broad categories and generalities renders a search warrant overly broad. The biggest problem with the lack of particular description of what's to be seized is it fails to rein in the searching officer's discretion despite their knowledge of specifically what they're looking for. That's Ingram versus State. The particularity requirement stands as a bar to exploratory searches, Anderson versus Maryland. Additionally, by limiting the searching officer's discretion, the particularity requirement safeguards the privacy and security of individuals against arbitrary invasions by governmental officials, Coolidge versus New Hampshire. A search of a safe located on premises subject to a warrant is generally not unlawful, but things aren't as simple as that. Generally, the scope of a lawful search of premises pursuant to a warrant extends to the entire area in which the object of the search may be found. It's Jackson versus State. This includes the authority to search through locked containers that would reasonably contain the items specified in the warrant. For instance, in United States versus Snow, a case from the federal 10th Circuit Court of Appeals, that's Colorado, Kansas, Wyoming, New Mexico, Oklahoma, and Utah, a locked safe was a likely source for specified documents and could therefore legally be opened because they fit inside the safe. In United States versus O'Neill, a case from the Federal District Court of the Eastern District of Wisconsin, a search warrant for firearms permitted the search of a locked safe as long as firearms could possibly fit in the safe. So obviously, if the firearm they're looking for is a howitzer, that's not going to fit in the safe unless the safe is gigantic. But for a handgun, for instance, that could fit in a safe, and the police could open a locked safe to look for a handgun, for instance. Basically, then, the fact that the container is locked doesn't create any greater expectation of privacy in its contents than the limited privacy expectation that exists in the rest of the premises. Government agents may lawfully break open locked containers which may contain objects described in the warrant. In United States versus Gonzalez, a federal 11th Circuit Court of Appeals decision, a warrant which authorized the search of documents and currency allowed the police to search a locked briefcase in the defendant's home. And in State versus Morris, the federal 5th Circuit Court of Appeals held that the police could search a locked jewelry box because the search warrant authorized a search for the proceeds of a bank robbery. Cash. Cash can obviously fit inside a jewelry box. The basic question then is, could the item the police are searching for fit inside the safe? If the answer is yes, then usually the search of a locked safe is going to be okay. But like I mentioned earlier, things aren't always that simple. What I'm talking about is that officers executing a warrant can't seize evidence not relating to the person and subject matter of the warrant. Moreover, any statements which led to the seizure of evidence in those two scenarios has to be suppressed as fruit of the poisonous tree. In Ibarra versus State of Illinois, the United States Supreme Court held that a warrant to search a place can't normally be construed to authorize a search of each person in the place. A judge in Ibarra issued a search warrant authorizing the search of a tavern and the tavern's bartender for evidence concerning the possession of controlled substances. After the police entered the tavern, they announced their intent to search for weapons, which was a little weird because the warrant didn't authorize the search for weapons, it just authorized the search for drugs. Anyway, while searching one of the customers, Mr. Ibarra, an officer discovered a cigarette pack that contained packets of heroin on Mr. Ibarra. The trial court in Illinois denied Mr. Ibarra's motion to suppress the contraband, finding that the search had been conducted under the authority of an Illinois statute which allowed law enforcement officers executing a search warrant to detain and search any person found on the premises. The Illinois Appellate Court affirmed Ibarra's conviction, and the Illinois Supreme Court denied his petition for leave to appeal. However, the United States Supreme Court reversed the state court and held that the officers lacked probable cause based on the search warrant to believe that any person other than the bartender would be violating the law. The court held that the heightened probable cause standard that governs searches and seizures requires that a search or seizure of a person must be supported by probable cause, particularized with respect to that person. This person-based particularity requirement applies even if the person searched is an object of the government's suspicion that led to a search of the premises. Searching E's safe exceeded the scope of the warrant. Could the warrant in E's case have authorized the search of E's safe? I suppose that some of the items which the warrant authorized the seizure of could have been in the safe, such as hard drives, CPUs, etc., but there was no evidence that the safe belonged to a person who was under investigation, and E, whom the police knew the safe belonged to, wasn't reasonably believed to be connected with the illegal activity, the exploitation of children. Nothing in the affidavit and application for the warrant mentioned E as being involved in the criminal activity which led to issuance of the warrant. And as just mentioned, when the warrant was executed, it was clear that the safe belonged to E. He arrived during the search, he claimed ownership of the search, and unlocked it with the correct code. Therefore, searching it exceeded the scope of the warrant. Exceeding the scope of the warrant made the search of E's safe unlawful. Since the search was unlawful, everything seized from it had to be suppressed. Now let's discuss how E's consent to search was compelled by the police. Aside from the problems with the search warrant in E's case that we just discussed, there's a problem with consent. E didn't consent to the search. What do you mean he didn't consent? He voluntarily opened the safe, didn't he? No, he didn't. Because his agreeing to open it was compelled. What do I mean? Let's talk about compelled compliance. Compelled compliance implicates the Fifth Amendment's privilege against self-incrimination. Justice Stewart's opinion in United States versus Mendenhall gives several examples of circumstances that someone's been seized. In other words, they're not free to go on their way and do as they please, even where the person didn't attempt to leave. These circumstances include the threatening presence of several police officers, the display of a weapon by an officer. I don't mean a cop pulling out a gun, they just have a gun on them. Some physical touching of the person, or the use of language or tone of voice indicating that compliance with the officer's request wasn't really optional. In State versus Wells, the Florida Supreme Court refused to allow any rule that allows the police to break open a locked or sealed container solely because the police have permission to be in the place where the container is located, because letting them do that would render the very act of locking or sealing the container meaningless and would utterly ignore a crucial concern underlying the Fourth Amendment, the expectation of privacy reasonably manifested by an individual in his locked luggage, no matter where that luggage is located. The court in Wells also held that even if the police have consent to search, if that consent doesn't convey permission to open a locked or sealed container, it's unreasonable for the police to do so unless the search can be justified on some other basis. For instance, where a defendant opened a tote bag for an airport officer to look into, and the officer spontaneously reached in and grabbed a nasal inhaler containing contraband, there was no consent. That's Major versus State, Florida 3rd District Court opinion. Also, Florida's 2nd District Court of Appeal ruled that consent for an officer to look at a pool cue didn't authorize unscrewing the cue to see what was rattling around inside of it. It's Moorhead versus State. And permission to go aboard a boat didn't equal consent for the police to open hidden compartments and containers on the boat. State versus Carney. The Fourth Amendment protects an owner's expectation of privacy in the contents of a closed container. If an object detected during a search is a hard shell closed container, then the incriminating nature of the contents aren't immediately apparent. In E's case, it is his admission to the police that the smaller safe was his, and his act of unlocking it was compelled compliance rather than consent freely given. The elements of compelled compliance, that is, the threatening presence of armed police officers, they're physically touching him, and the use of language or tone of voice indicating that compliance with the officer's request might be compelled, especially the police telling E to open the safe as soon as he told him he had the code, existed in E's case. Since the cops didn't know what was inside the closed, opaque baby formula container, the incriminating nature of its contents, the cocaine, wasn't immediately apparent. As a result, the police couldn't open the closed container and examine its content. Though the container could have contained F drives with incriminating evidence on them, the safe lay beyond the boundaries. Hold on a second. Lay beyond the boundaries of the. So, of course, the computer wants to update while I'm in the middle of a video. Anyway, incriminating evidence on the safe lay beyond the boundaries of the search warrant because it belonged to a person, E, who had no alleged nexus to the subject of the investigation, which again was the exploitation of children. He didn't have anything to do with that. Those are my thoughts on E's very interesting case. Post any thoughts you have in the comments below. Thanks for watching, and I'll see you next time.